Let us see the today's newspaper. It is 07 May 2015. Now, the first thing is an amendment is sought for the Whistleblowers Protection Act. Now, let us see the history of the act. How many of you remember the Shanmugam Manjunath, Satyendranath Dubey, who have raised the corruption in their respective organizations? The Manjunath was working with Indian Oil Corporation. Mr. Dubey was working with National Highway Authority of India. And he then wrote to the A.B. Vajpayee, then the Prime Minister. Finally, he was killed. It was the information got leaked from very much the Prime Minister's office. From then, the Whistleblower Protection Act was enacted in 2014. So in this case, who is a whistleblower? A whistleblower may be a person inside the organization or outside who makes a public interest disclosure regarding the corruption, misuse of power, or criminal offences by a public servant. Now, any person who wants to report about the corruption, then he can file that particular information or send that information to the CVC or State Vigilance Commission. Now, does this whistleblower need to reveal his identity to the CVC or SVC? Yes, he has to reveal this. Now, and the CVC and SVC, to conduct an investigation on that particular matter, they have to disclose the information only to the head of the department, the secretary of that concerned department, not below that. So it means that a relative protection is given to the whistleblower. Now, in this context, there are certain facts. The recent amendment act or recent amendment which was cleared by the cabinet consists of the following things. Now, the security of the state and the sovereignty and integrity of the country, these are the two things which are very broadly defined terms. Any matter related to the security of the nation is brought out of the purview of the Whistleblowers Act. It means that issues related to the defense, corruption, etc., if they are being disclosed, it means that there is no protection given or identity protection which is given under Whistleblower Protection Act is available to them. That's why it has been said that it's a retrogressive step and it weakens the fight against corruption in important sectors such as defense. If you can remember Bofors, Scorpion, Tatra, Truck, and everywhere the corruption was out because of the whistleblowers. Now the next coming is with regard to the recent US report, that is the Special 301. Every year, United States Trade Representative Office, it gives a report called as Special 301. So the Special 301 talks about the countries which might cause harm to the United States companies by not having adequate legal measures to protect the intellectual property rights. Now, it broadly defines the countries into two ways. So, the priority foreign countries and the priority watch list. Now, India is being kept under the priority watch list. Now, the priority foreign countries on this, there will be direct sanctions by the United States. But in the countries which are on the priority watch list, the United States tries to work through informal pressure, provide for various advisories, and educates them to improve the laws further and further. In this case, if you see, Indian Patents Act 2005, it provides for process and product patent both. But at the same time, there is one more thing we need to understand, that is called compulsory licensing. What is meant by this compulsory licensing? The government can provide for the compulsory licensing if in the event of the misuse of the patent or in the national interest, that is public interest, or to export to a country which do not have this particular drug where there is a public interest is being damaged. Let us see these things. What is compulsory licensing means? Let us see A has got a patent of a product X. Now, the government can order this X product to be produced by some other company which is not a patent holder of under certain circumstances. What are they? The first one is with regard to the misuse of the patent. It means if it is placed at exorbitantly higher prices. And next is 92, section 92, it says that especially with regard to public interest, health emergency, etc. is there in a country. 92A, it talks about export of the drugs. So what is this export of the drugs? For example, let us think, Nepal has a health emergency crisis. Now Nepal do not have the capability to produce the drugs to deal with the emergency. Now whatever the drugs necessary, Nepal issues the compulsory license and it requests to the Indian government to have these drugs. Then Indian government, in accordance with the Nepal's compulsory license, can issue the compulsory license here and can produce these drugs and can export that to Nepal. These drugs cannot be consumed in the national market or Indian market, can only be meant for export. These are the things which are called compulsory licensing. So, in this case, next ever, this drug was exorbitantly kept at higher price. Now by NATCO, and finally the permission, compulsory license was given to manufacture this drug. And similarly, recently there was a GLIVAC issue in which evergreening of patents was condemned by the Supreme Court. Now, added to that, the other thing is pre and post applications are, for example, if I am filing a patent within 6 months, I can provide for an opposition can be filed for that particular patent. This is called pre-grant opposition. Or within 1 year of the grant of the patent, an opposition can be filed. That is what is called a post-grant opposition. So in these cases, these two provisions are also available in India. So the US feels that they are harming the United States interests and India has been kept under the priority watch list. Recently, Prime Minister Modi, what he said is, to make Indian patent law on terms with the global standards, he is trying to revisit this. So what this article says is, which is not in the good interest of the country, because our patent law is very much in accordance with the TRIPS agreement, and many of the countries are trying to emulate our patent law. So that is what is not a good step according to the article. Next is 1993 verdict. Again, this is what is the first judge cases and second judge case. Now understand that, the first judge case and second judge case and third judge case. In 1993, the Collegium system has come up, which has given judicial primacy in the appointment of the judges. Now in this case, the central government argues that the 1993 appointment of the judges is not about upholding the judicial independence. The issue of judicial independence comes once the judges are appointed. Now, that's the reason why NJAC is a better system. That's what is the governmental argument. Now, what the justice argues is, what he said yesterday is, so yes, 1993 may be wrong, but NJAC has to prove beyond doubt that it is no way compromising the independence of judiciary. And next is governance of our cities. Now there are 7 important points which are stressed. The first one is the land and spatial planning with regard to the governance of the cities. Now most of the cities are underplanned. And next is, if you can see, there are parastatal bodies in the cities. If you take Delhi, along with the civic governance body as Delhi Municipal Corporation, you also have Delhi Development Authority. If you go to Hyderabad Huda Urban Development Authority. So these parastatal bodies, they plan for the land development. On the other hand, civic amenities have to be followed by these particular civic bodies. That's why the coordination is a major failure. And the next is staffing and capacity building. If you can recently see this article where the government is providing for the benefits to the states under smart cities missions and also under Amruta, one of the important reform the central government asked for is this. What it says is, every municipality has to train its own manpower. Municipality specific cadres have to be built. And the staffing and capacity building is critical to the success of the municipalities. The third one is finances. Do you know only 5% to 15% of the finances of the total expenditure of a municipality, of a city, they are generated from its own tax revenues. Most of the money comes from central governments or state government in the form of grants. Because of this, the local governments are made perpetually dependent on the higher levels of the government, and they have no predictability with regard to the flow of funds. And third thing, many a times, the higher level governments creates the funds or devolves the funds in relation to a particular project, linked them with certain reforms. So untied funds are not being generally provided for. And next is, if you can see leadership. So what is meant by this leadership over here? So Subhash Chandra Bose and Sardar Vallabhbhai Patel, all these people have started their careers from the urban bodies, from the grassroots level institutions. Now it means a strong leadership has to exist at the bottom of the organizations, so which is missing in India. And transparency and accountability, citizen participation. Yes, the transparency and accountability, especially after the 74th Amendment Act, the regular elections, etc. need to be conducted for the civic bodies. But the civic bodies, with regard to the property tax collections and other things, there are numerous complaints of corruption. And citizen charter implementation, etc. they will improve the accountability in the citizen administration. And next is the citizen participation. So how can you engage the citizen in municipal bodies? So if you talk about participatory budgeting, all these are the techniques for the citizen participation. Now let us see, in UK, there is something called a City Growth Commission which is appointed. Let us try to understand this. Now UK, 95% of the funds, they go to the central government because UK is a unitary state. From the central government, the funds have to flow to the local governments. So the central government first gets the funds. From there, the funds flows to the cities. Now, because of this, there is a lot of bureaucracy involved in between. So the funds are not timely available, and there is no innovation in the delivery of the funds. Now, because of this, the city's administrative bodies became lethargic. So for this, a City Growth Commission is concentrated with the spirit of new localism in UK. So what is this City Growth Commission does? So it provides the suggestions to the central government on two issues. One is process of devolution and what are the powers to be devolved to the cities. So that's why the similar system can be evolved in India too. Because Indian municipal governance is also highly centralized as like in UK. And next is, recently the government is very active in imposing certain financial restrictions on the NGOs. So the NGOs are important institutions to create the space for the public voice. So in every democracy there is a dissent of voice has to be respected. So in this case, so the US has almost fourth time it has warned India about these restrictions which are being imposed. And next is multi-drug resistant TB. What is the essence of this article is this. Now we are having something called as DOTS therapy under direct observer treatment strategy. So here the TB treatment program is not geared for the treatment of multi-drug resistant TB. So it means a multi-drug resistant TB means a TB bacteria which is resistant to the first line of drugs. So because as we are administering the first line of drugs instead of not testing the MDR TB probably under RNTCP, it may lead to further complications and increase the total incidence of the disease in the country. That is what has been discussed about. Last time there was a question on drug resistance in India, question on RNTCP in India. So again focus on this particular tuberculosis with regard to your mains concern. So thank you very much. Good night.